Hello, welcome to today's immigration tidbit. You want to come on an investment related visa, specifically an L1? Then you need to show that you've rendered services to the same employer when you come here to the US. So there's some issue sometimes as to what exactly is meant by the same employer, because when you work for company A, for at least a year in your foreign country, and then you are transferred or want to transfer to the U.S. to work for company B, that by itself will not qualify for the L1. So you have to look at the relationship of company A to company B to know whether or not you are going to be working for the same employer. So first of all, you need to analyze the corporate structure. Are the owners, the stockholders of each corporation, company A and company B, the same? If it's the same, then yes, you're working for the same employer for L1 purposes. Is company B owned by company A, or is company A owned by company B? That's another way that will show you're working for the same employer. Another way is look to see if company A and company B are owned by a third company, company C. Okay? If that's the case, then again, you are working for the same employer and rendering services to that same employer. So, it initially seems obvious to you when you start a company A and now you want to go to company B that it's not the same. But if you do meet these requirements, then it is. And sometimes the requirements are not there when I'm interviewing the client, and I can tell them, okay, well, if you buy this amount of shares, or Joe buys that amount of shares over here in company B, then it'll meet the requirements. It doesn't matter if the sale and or shares and or ownership changes just before you file the petition, as long as it meets the requirements when you do file the petition. And that's how you know you're rendering services to the same employer. Okay.